Hi, this is Charlotte Pierce coming to you from Indie Office Hours. We're live here at noon every week, and I will be going out of town, and the lovely Laura B. Williams will be taking over for the next 2 weeks, right?
Yep.
2 weeks, two sessions. So today we're talking about copyrights and contracts for indies, in particular indie publishers and authors. With Helen Sedgwick, who is an expert on this, and has appeared on Laura's show, The Writing Biz, to talk about this issue. We had IPNY had Mitchell Bragg. We weren't able to get him today, but he's an IP attorney here in New England, and he came to speak to our Metro Boston group twice. The first time, people had so many questions that they cut him off, or his presentation couldn't be finished. So he came back a couple months later, and he sort of finished it, but there were still more questions because things had changed. So, Laura, why don't you introduce yourself, and then we'll get Helen's take on what's going on with copyrights and contracts.
Sure. I'm the owner of Good Inklings, which I do content writing, content marketing, and social media consulting. And I also have the show on Wednesdays at 7:30, The Writing Biz, where we deal with the business of writing. I was lucky enough to have Helen on that show recently, and she's the author of Self-Publisher's Legal Handbook, which is an amazing book. There's so much information in there. If you're doing anything with self-publishing or writing, it's one of the best resources you can have, for sure.
Yeah, and there it is. Right after this, I'm going to order it because I think it looks like an incredible resource, and your blog post was very eloquent about that, Laura.
Oh,
but yeah, Helen. I wanted to mention that people who are watching, if you would like to comment or come in on the panel, you're welcome to. Just come to the Google Plus page and make comments, or you can type comments in on YouTube as well, and we will be picking up any questions that you have for Helen and the rest of us as best we can answer them. But Helen, this is a big topic. Where would you start if you're? I'm always kind of take the point of view of a fairly new publisher, someone who's able to do their own research, but isn't real well versed in the legalities of publishing books.
Okay. Well, one of the first things that writers need to remember is that they have to read the contracts. Many writers will go online and they'll be posting on a critique site, or they'll be considering using a company to help them self-publish, or they'll be hiring a freelancer, and they assume they won't understand the contract, or they just simply don't want to go there and they don't read the contracts. And then that's when you end up with some really unpleasant results. The first place to start reading a contract is look for any kind of contract. Look for what's called the grant of rights or a license, and read that one carefully. The words you want to look for are exclusive or non-exclusive. When anyone's helping you publish your book, you want to make sure you give them only non-exclusive rights. Here I'm talking about a self-publisher. Mm-hmm. So when you're working with Kindle or Amazon or Ingram Sparks or any other BookBaby, anybody like that, you want to look for the word non-exclusive. If you see the word exclusive, that's a red flag. You should probably stay away from it.
Now, as a small publisher, should you want to keep those rights if the author will go for it, or?
As a small publisher?
Yeah, if you're not publishing.
As a publisher and as a writer, a writer should be willing to grant a publisher exclusive rights only if the publisher can actually do something, make something out of them. Exploit them is the word. Actually, for instance, if it's only an ebook publisher, you should be giving them ebook rights, not print rights, translation, etc. If the publishing company can't use them. Rights can be, would an author grants rights, they're giving what's called a license, which is merely a permission to use, and that can be sliced as thin as you want it to be. It's just important to consider that and do some research, just like if you were researching how to create a character or structure a novel. Take some time and research licensing your rights, because once you license rights and you've given somebody exclusive or long-term, perpetual, or worldwide rights, it's very, very difficult to get them back.
Yeah, no, we are coming from the point of view of both. IPNY members are both self-published authors, and they're also, like myself, I publish other people's books. So I feel like that right is, you know, it does rest with the author, those rights. And if I can't do something with all those rights, I would feel bad not, you know, having them and not having the author be able to do something with their work that they originated.
That's fair and appropriate. Sorry, I thought I turned my phone off, but it's not.
I thought it was mine.
A law office, the phone rings all the time.
Yeah.
That's fair and appropriate, and and it's a good sign that a publisher is fair and author friendly when their contracts are fair and author friendly. And what you're saying, what you're talking about, we're talking about here, is the most important part of the contract. What rights are being granted to the publisher, and they should be tailored to what the publisher can really do with them. There are publishing contracts out there that are not as author friendly. I recently did a post about a contest for an ebook publisher, but by entering the contest, authors were giving them a 6-month exclusive right to pick up their book for ebooks, printed books, series, merchandising, movies, everything.
Wow.
Those are the kind of contracts that you don't want to sign. And they're out there, and authors need to get used to looking at the grant of rights or license sections of a contract, and if they don't understand it, get help.
Well, I have a question. Personally, before I made a deal with a publisher, I would take the contract to an attorney and have them look it over. When do you think that an attorney should look over a contract? When should you go to an attorney before you?
If you actually are getting a publishing contract, I think it's worth going to an attorney. Absolutely. It's just another piece of investment. It's a kind of insurance policy. Somebody has looked over it. Somebody who understands what things mean.
Especially the first time you deal with that publisher, it seems like, you know, when I did my contract with my latest author, children's book publisher, she took, well, I found it sort of a boilerplate contract. I looked it over. I made adjustments. We looked it over together, and so to make sure that we understood all the aspects. And then she took the final one to her attorney, who she met through IPNY. I can't say who it is. I don't think I should or something. But so it was, and then she had some changes, and then we kind of worked out what rights would be for what term of time, and we both felt good about it then. Yeah.
That's great. And even if you're going to an attorney, make sure you've read the contract and you understand what it means. It is a legally binding document, and
even if it's boring,
writers need to get out of the frame of mind that they won't understand it. You may not understand every single provision, but you should understand what rights you're giving away and what rights you're retaining.
Sure, absolutely. Yeah.
And what, like my crusade is to get rid of legalese. Now, how far can you go with that? Like, you know.
You can go pretty far. I think you can get a contract probably 95% free of legalese. There are going to be certain legal terms like indemnity that you're not going to be able to get away from. And
what is indemnity?
An indemnity. See, that's what. But An indemnity, typically a contract will say that the author represents and warrants that they own the work that they're licensing to the publisher, and that they have the right to grant the publisher the right to publish it. Fair, that's what the publisher is paying the author for, the right to publish this book. Then they're usually following the representations and warranties. There's something called, then the author says, the author agrees to indemnify, defend, and hold harmless the publisher in the event any of these representations and warranties are not true. So that means if it ends up that the book is plagiarized or there's some copyright violation and the publisher gets sued, by agreeing to indemnify the publisher, the author is agreeing to pay the attorney's fees and pay for any damages that are imposed against the publisher. Mm-hmm. So it's a really that's one of those terms that you do need a lawyer to help read it, make sure the indemnity provisions as narrow as possible. But other than the indemnity provisions, everything in the contract should be understandable to a non-lawyer. Yeah.
Did you have any questions about that aspect, Laura?
No, I just think that it's kind of the clearer that you make the language, if you're writing the contract, would be much more beneficial to both you and, I mean, if you're the publisher, you and the author, or either way. I mean, I would think you want to, just not framework it with so much legalese that they can't understand it.
Yeah. It's a bad, if they've written the contract so that you can't understand it, it's a bad sign.
Yeah, that's kind of what I meant. I mean, it doesn't seem it's very good for the relationship, a good start if you can't.
Right.
Yeah.
Generally, about any kind of contract, if you do a really good job of talking out the contract at the time you're entering into it, mm-hmm. then you may never have to reference it again, because there may never be a dispute, because you've already talked out all the issues. Mm-hmm. And that's true whether you're dealing with a publishing company or a collaboration partner.
Right.
It's always good to take the contract, really talk things out, make sure there's a meeting of the minds and that everybody agrees. Otherwise, you're just asking for trouble later on.
Yeah. Well, I used to work in a commercial real estate, so I understand completely about really going, point by point over the contract, making sure that both parties are real clear on it. And I don't think that can be said enough.
I wanted to go through some of the myths. Mitchell came in. He had 5 myths about copyrights and contracts or trademarks. I mean, copyright and permissions are another aspect of legal issues that publishers have to deal with. But people tend to confuse trademark law and copyright law.
Yes.
And Helen, how would you clarify that in a nutshell?
Well, copyright is really your ownership interest in the content of your book. It's your original expression. It attaches automatically as soon as you write your book down, whether it's on a piece of paper or on a hard drive. A trademark only has value in how it's used in the market. It's a brand name like McDonald's or Exxon or Xerox.
So if I had a series, I might trademark it, right?
If you had yes, one thing interesting about copyright is you cannot copyright a book title.
Yes.
You might be able to trademark it because it identifies your book in the market. So a trademark is from the perspective of consumers. Do they know your book by that title? It is hard to get book titles to be registered as trademarks unless they're a series or unless they're part of a consulting business or a larger business. But a trademark only has value in how it's recognized in the market, while a copyright exists and has value as soon as you put it on a piece of paper.
Let me make sure I understand this. So like the book, I don't know if you know the book, but there's a book on marketing called Youtility, Youtility, by Jay Baer. So that being part of his business and that he's coining that phrase to explain the premise of the book, he could trademark that utility?
That could, yes.
Okay.
In fact, if he's using that, if he's really coined a phrase and it's
Right.
it's unique and it's part of a larger business than just his book, he would be smart to register it as a trademark.
All right. Now I
Yeah,
understand.
so here's some things that Mitchell Bragg had pointed out. Copyright law, what it gives you, and what it does not protect, and as Helen said, did not protect individual book titles. I mean, the other issue, Helen, is that if you're an indie publisher and someone uses your something, I mean, how likely are you going to be to pull $5,000 out of the hat and sue them? You know,
I actually was just dealing with that at an email today. There are a lot of sites out there. I wrote a novel, Coyote Wins, and if I do a Google search of that title, I'll see free PDF of Coyote Wins, and there are these sites that purport to offer your book for free. I've never clicked on the links or the downloads because I suspect they're viruses or it's a scam and they're just trying.
Good point.
They're actually not trying to give my book away. They're using my book as part of a scam, which may be even worse.
Right.
You can send out what's called a DMCA takedown notice to those sites, but you could a writer could spend a lot of time chasing down these sites.
But the copyright, if you file it, it gives you sort of a mental, gives the offender a mental inhibition against, you know, like you might eliminate some of it, but not all of it if they really wanted to.
Absolutely always register your copyright, but there are always people out there who ignore the law. You have to understand, 99.5% of people actually want to do the right thing and they follow the law most of the time. But there's always going to be certain people out there who are going to cheat. And
or they're in a situation where they have to, like.
In many instances, it's not worth chasing them down.
Yeah.
A writer is better off spending their time writing their next book, promoting their book. That's going to be a more productive use of the time than chasing down these scammers. Now, it's not saying if somebody's actually out there reprinting your book, making a fortune out of it, you shouldn't chase them down. But some of these little guys are just part of the business that you have to.
It's like when we went to Russia. You go out into these little markets, and there were any American movie that you'd want. It looked like it was published, like you'd buy it at Blockbuster or whatever, but they couldn't be reached, so they really had a business going. But
and anybody who's going to be downloading a book from one of these free PDF sites probably wasn't going to pay for your book anyway. So it may not be a lost sale.
Well, Mitchell's myth number 2 is that a copyright filing is not necessary for protection, and you just mentioned, always file it. It does provide that sort of, public record, as he says, and if you really have a case, you will need that in court.
And it's easy to do. You go online, you fill out a whole bunch of fields. It feels like you type your address in about 6 times because you're. But it costs $35 if you do it online. It takes about 10 minutes. It gives you all kinds of rights. It puts the world on notice that the work is yours. And if you do get in a situation where someone is outright stealing your work, you have a lot more legal remedies, meaning money, that you're more likely to get. So it's a great investment for $35.
So it's still in the U.S. This is U.S.-based duration, right? 70 years.
U.S.-based, but there are treaties between many of the developed countries so that your U.S. registered copyright will be recognized and entitled to protection in a lot of other countries.
Right.
Maybe not in a Russian village, but
Yeah. Well, that's a good point. Yeah. Um,
Yeah, some of this is just uh, unavoidable. There are always going to be people out there who don't feel they have to follow the rules the rest of us live by.
yeah. And then there are things that people ignore because it's just like part of our popular consciousness that we think if we give someone credit, that's okay. That's not always okay, right?
This is, I think, the number one mistake writers and bloggers make is that they assume that if something's on the internet, you can pluck it off and slap it onto your own website or into your book. That in each case, you have to take a look at that image or that lyric or that quote and remember that somebody created that. And that somebody, that artist, created something of value, otherwise you wouldn't want to use it. And it may be entitled to compensation for that image. There are, and it's something that people need to be aware of, that not everything on the internet is for free, and you need to take about 10 minutes and consider who might own a piece of work. I'm actually working on 2 handouts that probably will be Kindle singles on exactly how to get permission for images and how to get permission for lyrics.
That's a good idea. If there was like a kind of a gateway where you could go and just say, this is what I'm trying to use. Who do I contact? I mean, there's publishing companies that have whole departments dedicated to this, and we're trying to publish 4 or 5 books where, it's me. It's like, what do we do?
Excuse me one second. I'm just going to unplug my phone.
Sure. Yeah. No problem. It shows that you have a busy legal office. I'll go on to myth number 4 of Mitchell's presentation, and I can write about whatever and whoever I want if I say it is fiction. And I think the one-word answer says it all. That is not correct. However, it's common sense there too, right?
Yes. If it's fiction, I recommend that you change the physical characteristics and you maybe mix people together, that you really mask the identity of the person that you're using. And the more villainous the person, the more you should mask it. And the same is true for companies.
Yeah, it's always stuns me how, these tell-all unauthorized autobiography or biographies are just like, people say some radical stuff about other people, like about their
and then
bodies.
Then there's nonfiction. In nonfiction, you can't. If you're writing a nonfiction piece, it's going to have the real names and the real people.
Yeah. That's true. Yeah.
If you are doing that, I would suggest, if you have any nervousness at all, to consult with an attorney who's used to reviewing manuscripts for those issues.
Good point.
Particularly if it's nonfiction or what's called docufiction, like In Cold Blood was, where there's fiction and then the author's also speculating on a lot of conversations or a lot of what might have happened. There's so many, you have to look at both the forest and the trees with those kinds of works, that those are times when it's worth hiring an attorney.
And people tend to not want to do that, because if you do if you go to someone and say, is it okay if I say this about you? They're going to say no. I don't want that out there, even if it's true. So.
Everybody has a level of risk that they're comfortable with. Some people can't sleep at night if they take any chances. Other people will just say, well, if something happens, I'll retract it. Mm-hmm. And that's an individual comfort level that somebody, you have to decide for yourself. Just because somebody else is willing to take the chance doesn't mean you should, and just because you're willing to take a chance, somebody else might not.
Yeah, here's an interesting thing. Libel is written, slander is spoken. Is that how you would phrase it?
Yes, and then there's this new thing called Twible, which is Twible. It's libel on Twitter or Facebook or on social media. There are
Wow. Have you had some cases of that come through?
No, I've been reading about them. Generally, what the courts are finding and juries are finding is what people post on Twitter or Facebook or TripAdvisor or Yelp is opinions. And opinions are protected. They're not, you can't, even if you say a really vicious critique of somebody, if it's not a false statement of fact, it's not defamation.
Was that you that posted that piece about the French blogger who had?
Yeah, I saw that today. I didn't read it all the way through.
She blogged about a restaurant in in Cap Ferrat, and it was hilarious because they went and sued her and got the French court to say that it was restraining their business, even though it was all true. But then they were saying that that it had the effect of just highlighting the failings of the restaurant.
Yes, the rules in France and England are different from here. There has been a problem with, I know TripAdvisor is suing one reviewer who, and I guess this is happening a lot in restaurants, people come in, they get a meal, and they get to the end of the meal and say, you're going to comp me on the meal, give it to me for free, or you're going to cut my bill in half, or I'm going to give you a bad review on TripAdvisor.
Yep.
There are people out there. Now that's
bad humanity.
Yes. Again, going back to the small percentage of people who don't feel they have to follow the rules. So there is a case now in England that I've read about where a TripAdvisor reviewer went to a restaurant, they refused to cut his bill in half, and he wrote a bad review about them on TripAdvisor, and they are suing him. See, you can always go too far. There's the anybody can sue anybody, particularly if a lot of emotion is involved. And with defamation cases, since they usually involve paternity and fidelity and infidelity, they're very emotional. You might think you have no money and no one will go after you, but if you get somebody angry enough, they could and might go after you.
Exactly. Yeah. And then you have Mitchell makes some good points about invasion of privacy and all that. I mean, it's just like a little layer of review that you can put over a book, like a proofreading, like a final proofreading or something. It seems like, and
like a checklist.
Yeah.
Yes, I cover a lot of this in my book. One of the things I advise writers to do, whether it's fiction or nonfiction, is for the defamation issue, is avoid labels. Don't call somebody a crook or an idiot or a pervert or any of those loaded words. Describe what happened. Describe the facts. Describe your feelings about the facts. And let your writers come to their own conclusions about what labels to attach to a person or a character.
Your readers, yeah.
Yeah,
in other words, they'll be saying, I am not a crook.
Oh. Right. It actually, some of these things will make your writing better because it's the old show, don't tell. And also if you're fictionalizing these characters, if you make them more universal, you take them away from that person's actual physical characteristics and you make them more universal, you actually might make your writing much better.
I think that's a really good point, and you'll make your readers more loyal. You'll have a better foundation. Wouldn't you say that's part of platform building, Laura?
Yeah, absolutely. I mean, but you want to. You don't want to do anything that's going to harm your overall reputation.
Yeah.
Because it'll follow you. I was just reading today that Fry guy who wrote the book, oh my goodness, Charlotte, you'll know. What is his name? Fry, that wrote the book on being a addict or something.
Oh, A Million
Oh,
Pieces?
Yes, million. Yeah,
yes.
yeah. He's got a new book out,
Oh,
and it's actually the way he's selling, marketing the book is that this one's not true either, but it's entertaining. You know.
okay.
So
Well,
yeah, but I personally wouldn't want to do anything that would come back and bite me or damage my reputation. I
yeah.
just
Now
It
the other
depends on
thing.
the writer. There are writers out there who want to be pushing the
right.
edge of the envelope and
Yeah.
want to be controversial. Um, Again, goes back to how well do you sleep at night when you're taking risks like that?
And all of this has me like wanting to run out and hire an attorney right away, or retain one. But what is this prohibitive for independent publisher? I mean, I don't have a lot of cash to like 500 here or 500 there to give to an attorney to review stuff. Are there ways to kind of work it where you can at least take like most of their work away and then just have them do a final thing or something? Or
Yes, you might. What you can learn to do is spot issues. You can spot this are the 2 pages that are worrying me, and so if you've done your homework and you've really taken it as far as you can go, then you can ask an attorney a very focused question. In many communities, there are lawyers for the arts organizations where you might be able to find an attorney who will do it for no money or very reduced fee. Sometimes they say it will be a reduced fee and then never even send the bill. It's just a way of
yeah.
making sure
How
people
about
don't.
law schools and places like that? Can you get like I had the University of Washington Dental School do my dental work when I was, and I'm wondering if, at least to spot issues or, like to give them some
Yeah,
practice.
I worry that you're getting somebody without too much real-world experience, and so you're going to get what you pay for.
Yeah.
Right.
I would be nervous about that.
Well, my book editor I use a lot, Tanya Gold. She's also a board member of IPNY, but she's really good at spotting legal things. So you
Editors,
can have that layer already built in.
an experienced editor is used to spotting these issues. Maybe not knowing how to solve them, but saying, this is one the attorneys need to look at.
Great.
So that is
yeah.
one of the benefits of an experienced editor who is far cheaper than an attorney.
Yeah, yeah, and you kind of have that built into your publishing expense. I mean, you should if you're doing everything yourself. There's, that's a very rare person that can do everything well.
But I would think too that when you're designing your initial contract that you're going to be giving to your authors, that original contract, that would be the time to have an attorney look it over and then talk to them about, well, these are the changes that might come up. What kind of language should I use when I'm adjusting for these changes, like rights issues and things like that. I think that would be money well spent right there at the beginning. And
now, Helen, is like if you say I was sitting down and had a Coke with my friend, am I supposed to pay Coke for that mention, or
No.
shouldn't they be glad that I'm saying Coke?
No, with trademarks, you can use the name of a company's product or the name of a company in your writing, so long as you're not making it look like you're affiliated with them or somehow they're promoting your product. If you're not borrowing their trademark for trademark purposes, for the purpose of promoting your work, it's just having a Coke or a Starbucks is part of the setting of your story.
Not to be worried about too much, unless you're putting their logo on your cover or something.
Yes, if you're making it appear somehow you're affiliated and you're piggybacking on their trademark rights, then you run into problems.
Got it. Yeah.
And there you're more likely to get a lawyer letter.
Right. Well, you're going to get client letters unless you probably answer your phone. So I think I think we're gonna probably have to wrap it up and let you get back to work. But this has been an awesome session, and like Mitchell said, I think we need to revisit it probably several times a year. But is there anything last parting words that you'd like to mention, and any projects you got coming up, or?
Oh, I'm busy. I just launched, as I said, I launched my book in June, so I'm still on the blogging circuit and on the Google Hangout circuit.
Like this one.
You know, letting people know about the book. And the goal of this book is to give writers the tools to do a lot of this themselves. You know, so that they don't, if they need to call an attorney, they've taken it as far as they can go without having to spend that kind of money.
I think I'm going to do it, get it right away. Yeah.
I'm going to do one for focus more on bloggers as well. Some of the issues are the same, but with blogging there are some additional issues. And you know, some speaking engagements. I'm having a great time, and I'm really happy to help.
Well, I'm getting the book as soon as we hang up, and I'm going to keep it on the shelf with Tom Wall's book about how to, you know, the finances of publishing. I think those would be like two things that I don't do very well. Probably need to have on my shelf. But Laura, do you what's going on besides your hangout and all that? What's going on?
My grandson's coming to hang out with me today.
Oh, I'm so glad.
No.
Put him on the hangout.
Yeah, I've been concentrating on that, and I just put up. I now have a podcast that goes along with that. So I've been real busy trying to get those organized and get those promoted, and that all seems to be going really well.
So it's thewritingbiz.com.
Yep.
And so yeah, you are an overachiever. Laura is the co-host of my show, and she's like, "Oh, by the way, have you written the blog post for the show yet?" And I'm doing it. I'm running as fast as I can.
Or you're rowing as fast as you can.
I'm rowing.
Right. That's right. Yeah.
Are you a rower?
No, I'm not. I've done it a few times years ago down near Sausalito here in Northern California. No, I'm more of a bike rider and a walker.
Yeah, you look healthy. I keep threatening to, since we're in Boston, I keep threatening to come down to Florida to row and stay with Laura and row down there in the winter.
Yeah, you don't want to do it right now. It's so miserable.
The Charles River was completely iced up until about mid-April this year. It was crazy. Right. But thank you both for coming in, and we are going to definitely have you back anytime. I'm getting your book right now, and we'll talk to you all soon. Next week, what do we got, Laura, next week? I'm going to be in the UK.
Next week is websites. We're going to talk about building a website and having it really identify with your brand and, you know, how to make it look nice.
Yeah, and Laura knows what she's talking about because she helped me. She babysat me while I went through and set up my WordPress site. So I'm very grateful. Thanks all, and we'll see you next week, Tuesday at 12. Thanks, Helen.
Thank you.